Hello. Hi, everyone. Thanks so much for coming. So this is part of our Bacon Immigration Policy Law and Law and Policy Program Speaker Series. We're so lucky to have with us in person two of my former colleagues from the ACLU Immigrants Rights Project. We have Judy Rabinowitz, who is Special Counsel at ACLU IRP, where she has been since 1988. Previously, she was Deputy Director of IRP, where she litigates class actions and impact cases on a variety of issues, with a particular focus on challenges to immigration detention. She is, in my view, the nation's and everyone's view, who works on this, the leading expert in the nation on immigration detention. She's played a leading role in the major Supreme Court cases on immigrant detention, including Judys v. Davis and DeMore v. Kim, which she argued before the Supreme Court in 2003. We also have with us Michael Tan, who is the Deputy Director of the ACLU Immigrants Rights Project, 22. His practice also includes work on immigration detention, as well as access to education and the rights of undocumented young people. He previously clerked for Judge McCune of the Ninth Circuit. He's won numerous awards for his litigation, including the California Lawyer of the Year Award, and recognition as one of the top 40 under 40 lawyers by both the National Asian Pacific American Bar Association and the National LGBT Bar Association. On a personal note, Judy has been a mentor of mine since before I was a lawyer. Yeah, of ours. I worked with her as a law student, then I continued working with her as a fellow and attorney at IRP. She's taught me well over half of what I know as a lawyer, and pretty much everything I know about immigration detention. Michael and I started out at the ACLU together as lowly fellows. He was a lowly first-year fellow when I was a more senior second-year fellow, and now he has risen above and beyond. But really, both of them have been so deeply important to my practice and my work and my development as a lawyer, thinker, and scholar. So thank you so much both for being here.
Well, thank you so much for inviting us. I mean, it's just really great to be here, and I really appreciate it.
Well, let's get started. So we're just going to do this sort of interview style. I have a few questions, some of them for both of you, some for one or the other, and then we'll open up for audience questions, and also if you have any questions that you'd like to ask the folks here. So my first question, okay. Well, my first question is for Michael. So it's a question about the ACLU. Why are immigrants' rights a concern of the ACLU National? And what are the major focus areas of IRP in this area?
Great. So thank you, Eunice, for hosting us today. Thank you, everyone, for being here. Thank you to the folks on the Zoom. I hope you can see and hear us. It's really lovely to be here at the law school with all of you. I guess to answer your questions, so immigrant rights has sort of been an ACLU issue since the inception of the ACLU. The ACLU was founded, as some of you may know, in 1920 in response to the infamous Palmer raids. So these are the raids in 1919 and 1920 that Attorney General Mitchell Palmer staged against so-called radicals, immigrant radicals in the US. And in part, this was driven by some anxieties about leftism, political radicalism on the heels of the Russian Revolution. So that's actually the founding of the ACLU is in an immigrant rights fight. And I think it's been, immigrant rights has become only more of a core issue, particularly in recent years, and certainly since the founding of the ACLU Immigrant Rights Project was founded in 1987, so some 35 years ago. I think, so the ACLU is a very large and diverse organization. IRP is itself is very large, and I think people would answer the question you asked, why is immigrant rights a core civil liberties issue, civil rights issue for ACLU attorneys? They answer that question in really different ways and at different times in our kind of history. I'll give you my answer, which is one core reason why I care about immigrant rights is I think the defense of immigrant rights, I think the defense of immigrant justice, immigrant communities is actually core to our survival as a multiracial democracy. We've all just lived through the election and presidency of Donald Trump. a presidency where we saw white nationalists hijacking our federal immigration system to detain, deport, and expel as many people as possible, and to shut down as many legal pathways to immigration as possible, in service of an explicit white nationalist agenda. You know, President Trump told us that the reason he was doing this was to stop Mexico from sending their rapists, to keep Muslims from entering the country, to stop people from shithole countries coming to the United States. And so I think that sort of puts in very stark terms what the stakes of the fight are today. I don't think restrictionists should be heard to say, well, really what we're doing here is defending the rule of law. I think the idea that the Trump administration was driven by a commitment to the rule of law in any area of government is frankly laughable. And they told us what they were doing. So that's part of why I really care about immigrants' rights. And more affirmatively, I think we all thrive when all members of our community are thriving, and that certainly includes immigrant members of our community. I myself am an immigrant from a family of immigrants, and I'll talk more about that later. But that's why those are some of the reasons why I see immigrant rights and immigrant justice as core ACLU issues.
Thank you. Well, my next question is for Judy, and I wanted to know, how has IRP's focus changed over the years since you've been there?
Yeah, sure. And I'm just going to add a little bit to what Michael said, just in terms of what maybe it's not so much about why immigrants' rights is an ACLU issue, but why it's my issue. I am not an immigrant with my family. My grandparents were all immigrants, and that's very much something I grew up with, the notion of just people who had to flee their countries to find another place to live. But to me, and they fled because of persecution in Russia or what's called Ukraine, whatever. But for me, and I came from a left background, I was involved in, fighting US imperialism countries, and really made a decision about whether I was going to do international human rights work or immigration, and I was involved in work around the war in Central America. And for me, immigration was just all about equality, that it was sort of, it just epitomized, people come here because they can't have a life somewhere else. And that to the extent that you believe in equality, which I do, why should somebody, because they're born here, have a different, trajectory, not be able to support their family? And for me, allowing, it seemed like immigration was a positive, that you're allowing to sort of the redistribution of wealth in some way. So anyway, that's my personal, as along with the fact of providing refuge for people who are fleeing persecution. So in terms of how, and the other thing about why immigrants' rights is an ACLU issue is because immigrants have always been are easily scapegoated, and the kinds of things that they're scapegoated for are the things that are going on. Whether it's disease, whether it's politics, whether it's crime, it suddenly becomes immigrants are the ones, and to the extent that they can take rights away from immigrants, it makes it easier to take them away from the next people. And so we saw that with the 1996 laws, when one of the big focuses was getting rid of habeas corpus and judicial review. And the sense was, if they can do this for immigrants, and immigrants are an easier target to do it, then that's going to make it easier for them to do it for everyone else. So that's another reason why it's an ACLU issue. In terms of how, I've been at the ACLU since 1 year after the Immigrants' Rights Project started. So I've seen how, lived through the changes in focus. And, I would say that, the big change is that initially there was at least more, there were different issues that were going on. When I started, there had just been a legalization, the 1986 Immigration Reform and Control Act. And so there were issues around that. And then, we saw more of the war against crime and how that affected, immigrants and the 1996 laws. And then we saw 9/11. And so what we have been, this particular issues we focused on have changed depending on what was going on. But more broadly, I'd say that, initially, at least when I came to the ACLU, there was more of a chance that we could look at sort of not just defending immigrants' rights, but trying to expand immigrants' rights. So that was our goal. And I think that over the years, it's become much more defensive. Than just really having to defend against the onslaught against immigrants. There's been some movement to expand, but particularly, getting into some of the other things we're going to talk about, particularly given how the court has evolved, the Supreme Court, it's really gotten to a point where it's very hard to sort of think that we're going to, and I think more we're just worried about losing, preserving what we have. So, I mean, in some ways, kind of the zenith of what we had was, right with Zedvitas and St. Cyr. And I guess it was right before 9/11 when, we had really good decisions, and Zedvitas in particular was an indefinite detention case where the court, basically said, we're not caving to the plenary power doctrine. We're recognizing that immigrants who are detained are subject to the same, due process standards that apply to civil detention. And there was some hope that we could start to free ourselves from this plenary power doctrine that has sort of made immigration a stepchild of constitutional protection that doesn't apply. So that has, now we've seen the most recent case, and then I'm going to shut up, the Rassingham, where instead we see like a retraction, where what we've always assumed, which is at least there was due process for people inside the country already. Now that's being, called into question. And, I think that we're very concerned about, not bringing cases to the court or not letting cases go to the court that are going to allow them to restrict rights because of just who the court is right now. So that's it.
Well, I wanted to ask you both questions about your border litigation. Of course, here in Tucson, we're just north of the Mexico-US border. So what are some of the major areas that you're working on, the major litigation that you're undertaking around border policy?
Should I go next?
You can ask because I just talked a lot.
Sure. One of the major focuses of our litigation in recent years has been our challenges to the so-called Title 42 ban, which essentially is an order issued by the CDC during the Trump administration, purportedly in response to the COVID-19 pandemic, that essentially authorize federal immigration authorities to summarily expel asylum seekers coming to the border. That's sort of in broad strokes. This is sort of an unprecedented use of the public health authority. There's been really good investigative reporting strongly suggesting that essentially the Title 42 was issued on pretextual grounds. So this is really about Stephen Miller and friends seizing on very old, long-standing public health authority and basically twisting it to use it as a form of immigration control and not actually to use it to protect public health. We brought a series of lawsuits challenging Title 42, and just to underline, the practical impact of Title 42 expulsions has been devastating to the asylum system. The mass expulsions have largely shut off access to asylum and protection to large swaths, the majority of asylum seekers coming to the southern border. And so we brought a series of lawsuits challenging Title 42 in the district court in DC. The first wave of cases challenged the application of Title 42 to unaccompanied kids. So basically kids coming by themselves to seek protection who were being summarily expelled pursuant to that order. We won a series of court orders banning the application of Title 42 to kids. And ultimately, once the Biden administration came in, they backed down from, thank God, they backed down from expelling children under the CDC order. However, they kept the order in place as to other asylum seekers. And so we brought the next wave of litigation, and in particular, the main case is a case called Fleisha, which is a case on behalf of asylum-seeking families, arguing that they too, that their expulsions were illegal and in violation of, among other things, the asylum laws. Much to our disappointment, the Biden administration has kept Title 42 in place. It remains in place today, despite their commitment to following the science. They've got really a scientific basis for keeping Title 42 in place. And despite their commitment to restoring the asylum system, they have not restored the asylum system. They've in fact continued a Trump era policy of expelling asylum seekers. And so it's been devastating, but the good news is very recently we won a very strong decision in the DC Circuit Court in the Felicia case, forbidding the government from expelling people to countries where they face persecution or torture. I think that has mattered, and there's been significant news reporting in recent weeks suggesting that finally, especially with the changes in the pandemic, the litigation pressure, and I'm leaving out lots of aspects of the story. We can get more into the details if folks are interested, but it seems like the Biden administration finally might be ready to rescind Title 42 as it should have done a long time ago. And so, although I very much share Judy's assessment of the courts and the landscape, it's grim. I do still think, and Felicia is a good example of this, there's still really important interventions to make to change the overall political dynamics, that drive kind of our federal immigration policy. So that's one example of our work in litigation. I think you're going to do MPP.
Right. So the other part is the migrant protection protocols, or the return, remain in Mexico policy that Trump began. The difference between Title 42 is people are expelled. They're not put into, given an opportunity to apply for asylum at all. They don't get removal orders. They're just gone. The practical effect is that they're returned to places where they're in danger, but it's a different sort of system. The Remain in Mexico, which started before the Title 42, is one where people who come to the border seeking asylum are put into proceedings, but forced to go back to Mexico and wait for their proceedings in Mexico. So that was under Trump. We challenged it, and we were successful in winning an injunction against it, that it wasn't statutorily authorized and violated the withholding statute. And but bottom line, the injunction that we got from the district court was stayed pending an appeal to the Ninth Circuit, and then when it went up to the Ninth Circuit, affirmed the injunction, that was stayed. Both were stayed by the Supreme Court. So MPP would existed, and about probably around 60,000 people returned to Mexico during the Trump administration, and it was one of the things that advocates really were, very strong about, advocating against this, pointing out what happened for people in Mexico is that obviously it was very dangerous in border areas. This is, the State Department's own reports showed that it was like very, very dangerous to be in the areas where they're sending people. In fact, we ended up doing a lawsuit about this one particular area region of Mexico where they returned people to Tamaulipas, where the State Department had its highest advisory: do not travel there because it is too dangerous. And yet, even at the same time as it had this thing to, United States residents don't travel there, people in the government don't travel to this area, it's too dangerous, there's kidnapping, there's no, the Mexican government can't control the cartels, it's just, lawless. At the same time, they returned people there. And yet they claimed that people were going to have a fair shot at applying for asylum there, that Mexico would protect them, they'd be safe. And that was all obviously, crazy. There was no basis for any of that. So there was tons of documentation about how people who were returned to Mexico were subjected to kidnapping, to rape, to, assaults, to, extortion, torture, all of these stories. Really horrendous stories about, young kids who saw their parents tortured, young kids who saw their mothers raped, I mean, just by the cartels, all of this. And at the same time, there was no way for people to have access to attorneys, so there was no way to really to have a meaningful opportunity to apply for asylum. So all of this was documented. There was a lot of advocacy about it. And during the election, Biden took a very strong position that he was going to end MPP. And when he got into office, that was something he did do. He suspended MPP pending a review, and then they involved a review, and then they started to unwind the process. And then what we've seen, I don't know if I'm repeating stuff that everyone knows, but then we had, what happened was that the state of Texas and Missouri did their thing, which is what they've been doing to Biden policies that try to undo what Trump did. And they basically say you can't do it, and they go in front of the Trump judge in Texas who says, yeah, you can't do this, and basically ordered the government to re-implement MPP. So this has just been a disaster. I'm not going to go through the step-by-step, but bottom line, despite the Biden administration's attempt to end MPP, they were under an order to re-implement it. There's different questions about whether they really had to implement it or not, whether they caved. They were terrified of being under this injunction and being held in contempt. And so they started re-implementing MPP this past December. Meanwhile, they also set up another termination decision, and the whole thing is going up to the Supreme Court, not on the validity of MPP, just on two issues that the Fifth Circuit, basically came up with this crazy view of the immigration statute, which was that even though MPP is the exercise of this provision in the statute that says that the government may return people who are arriving from a contiguous territory, may return them pending their removal proceedings. It says that it had to, that there was no choice, that if it couldn't detain them, it had two choices: detain them because the statute says shall detain, or return them, so that there was no way that it violates the statute to end MPP. It's a crazy, crazy reading of the statute. And it also involves reading the parole authority, which says that they can release people on parole. They read it very narrowly as only allowing release of a few people, not large numbers of people. So it's really a significant, we just really have to hope that the Supreme Court will reject that reading, because otherwise, everything is, it's just crazy. I don't see how they can do anything at the border, except lock everyone up or return them to Mexico. That's basically what the Fifth Circuit was saying. So that issue is going up to the Supreme Court, and the other issue that's going up is just when the Biden administration issued its second decision saying we're ending MPP, they brought that to the Fifth Circuit and said, you need to now remand this case to the district court to consider whether we've cured what the district court had said were the failure to comply with the APA, the failure to provide sufficient reasons. And the Fifth Circuit refused to do that, said, no, this isn't a new decision. This is just post hoc rationale. We're not going to do this. The first decision was inadequate, and that's it. So the only issue that's going into the Supreme Court is whether the Fifth Circuit was wrong to not consider this new decision and to send it back to the district court. So anyway, this is now going to be argued before the Supreme Court, I think, the third week in April, 26th of April, and we'll see what the court does. In the best possible scenario, which we have to hope for, is that they'll say this statutory argument's wrong. We just hope they'll do that. And that they'll say, yes, this was a new decision and it shouldn't, the Fifth Circuit should have sent it back to be redetermined, and that in fact, because the new termination decision replaces the one that was the basis for the injunction, there's no basis for an injunction anymore. And basically we hope that they'll vacate the injunction. This is the best of all possible worlds. Even if they do that, this will leave room for Texas to go back in, amend their complaint and say, well, we're challenging the adequacy of the second termination decision, and go back before the same judge get another ruling that it's inadequate, go back to the Fifth Circuit, get another ruling that it's inadequate, and, you know, it just could be, we could be stuck with MPP for a while. So, sorry to cram that all in so quickly, but, that's
I mean,
basically where.
the one thing that just to add, like, I think that's good, is thus far, the Biden administration seems to be making fairly limited use of MPP. I think query whether that will change, whether the judge in Texas will put pressure on them
Right.
to let put more people into it. I think if they get rid of Title 42, will they feel more pressure to use return to Mexico? So I think it's a very volatile.
And this was a whole concern also about why they, you know, did they really need to start implementing NPP again? Or there was always within the administration different viewpoints about some who seemed like, oh, let's start NPP again. We're going to need it when there's not Title 42 because they're completely freaked out at what's going on at the border. So it's hard to know like how much of this is a result of sort of, you know, this disjunction within the administration about how much they really want to get rid of NPP and how much do they want to have it to use. So we'll have to see. I mean, but at least it's true. They're saying that they don't want to use it. And the second termination decision was very strong in terms of providing all the reasons why MPP was wrong and why there wasn't another way to do it. And so that also provides us with ammunition if we're left with it, with going back and saying it's arbitrary and capricious to be doing MPP at all, because even under their own, they've basically conceded that, you know, you can't do it in a way that's that doesn't, you know, deprive people of their fair shot at getting asylum.
And if you're interested in MPP and the litigation more generally, I would encourage you all to read the US's brief that was just filed in the Supreme Court. It's quite good at laying out exactly why Texas's statutory argument is both as a textual matter and then as a historical matter and as a practical matter completely insane. We can talk more about why it's completely insane on those 3 fronts if folks are interested. But also why the Fifth Circuit's refusal to give any weight, any consideration of the Biden administration's attempt to terminate MPP after the district court said, no, you have to do it. Basically what the Biden administration did, those of you who are taking admin law, I mean, that's what federal agencies do. Like a court says, you didn't get it right the first time, this is why. And then usually what happens is the agency has a chance to go back and say, okay, I'm gonna address your concerns. And here, essentially, among other things, the Fifth Circuit said, well, no, we're gonna ignore that, because that's all post hoc. Like essentially you're acting in bad faith. You decided to just, you know, end this like from the get-go. And like, despite the fact that what the agency was doing was responding to a court order saying, you need to do this, you need to justify this decision on better grounds. So I think if you're interested, it's a really insane, it's a good way of putting it, but I would recommend that.
And there's also an Amigos, there's 2 Amigos briefs that we've been involved in. One is an Amigos brief on the statutory argument saying why it's crazy that is by former DHS and INS officials saying this is crazy, and we're able to get bipartisan, you know, there's at least 4 Republican people from Republican administrations that signed on to it. And you know, the position they're saying is we all have different views on MPP, but this is crazy. This is really crazy. You can't let, you know, this would completely disable our ability to control what's going on the border.
Yeah, and if Texas were right, it would mean for the last 25 years, every administration, Republican or Democrat, has been in flagrant violation of immigration laws. So it's sort of, oh, really?
So we just have to hope that, you know, we just have to hope that the sport.
We can dig out of this rabbit hole if
Well,
you want to. We can either keep going.
Just one last thing to say. I think one of the things that was most alarming though was that when the Texas judge issued the injunction, the government sought a stay, and the Fifth Circuit, the district court obviously wouldn't stay it, the Fifth Circuit wouldn't stay it, they went to the Supreme Court, and the Supreme Court wouldn't stay it either. This is the same Supreme Court that stayed our injunction that said MPP shouldn't be allowed to take effect because it's unauthorized, it violates the law. This outrageous injunction, which was just, you know, basically a power play to say, we don't like this change in policy, that contradicted the, the statute, the Administrative Procedure Act, they refused to stay it. They allowed it to take effect. So it's just.
I mean, sorry, it's a bit less. I mean, like, just one further example of the outrageousness. It's like Texas is claiming it's being harmed by the fact that the Biden administration is letting in asylum seekers who would otherwise be returned to Mexico under the NDP. So what are the harms to Texas? The main harm, one of the main harms they said is, well, it's forcing us to give people driver's licenses. And so this is one of the reasons why we need an injunction requiring the reinstatement of return to Mexico. And so you look like, as Judy said, the US sought a stay in the Supreme Court. They filed a brief, that's what you do. And like one of the first lines of the brief is, because like under the, I don't know if you know about stays, but like it's basically one of the aspects of the test is you kind of like weigh the relative harms to the parties in deciding whether you should stop, issue an injunction, essentially, staying the court order below. And so one of the first lines of the brief is like, if we're forced to reinstate MPP, it will cause untold harm to asylum seekers. It'll disrupt our foreign relations with Mexico. It'll completely disrupt our ability to implement our understanding of how the border should be managed. On the other side of the balance, Texas will have to give people some driver's licenses. So maybe the balance of equities favors the United States here, and the court should keep the status quo in place while the litigation is playing out. And yet,
And also the thing is the numbers of people before they got rid of MPP, before they terminated MPP, the numbers of people who were being put into MPP had really shrunk to a small amount because most people were being expelled under Title 42. So it wasn't even large numbers of people.
Well, we did, so those of you who are 2Ls, last year we had an event with David Cole, who was the legal director of ACLU, and he talked about the Supreme Court's shadow docket and what it's been doing with the states and what it's not doing with the states. So we have that recorded. But I do want to move to our next question, which is, I think you both identified some of the limits of litigation. So this is a question for Michael about what other areas of work the ACLU engages in particular, it's non-litigation work.
Sure. So we have, just to kind of briefly lay out some of our structure at the ACLU. So we're both from the Immigrant Rights Project, which is a project of our National Legal Office. It's where sort of all the litigators at the National ACLU live. And it's organized according to these teams that are focused on specific issue areas. So LGBT voting, national security, immigrant rights. And then we have state ACLUs across the country, and all of the folks in those offices, for the most part, are kind of civil rights generalists. Like they're just really amazing, great civil rights lawyers who know conditions on the ground, who know local judges and whatever. And so one of the great things about doing litigation at the ACLU is this unique structure. I'm not sure if there's another civil rights organization in the country that's structured in a similar way, where you have kind of subject matter expertise living like at the mothership or the nerve center. I don't know what the metaphor is. Like these experts in all of these areas of civil rights practice, but then folks on the ground who are just really great generalists. And we are able to partner together to do the litigation that we do. So that's one thing. We then have this other separate, and this gets to your question, arm of the organization, our National Political Advocacy Department that sits in DC, and they support and engage in advocacy campaigns at the federal and state level on all of our issues. And so, there's a lot of progress to be made. I think we were talking about this right before the session, particularly at the state and local level, that I think can often get overshadowed. And even we can often forget because we're so focused on the pathologies of what's happening in the Supreme Court or with the federal immigration system. But so, for example, like we've done really successful work with many partners in Massachusetts to secure passage of their state bill extending driver's licenses to residents of Massachusetts regardless of status. We do a lot of work opposing what are known as 287G agreements. I don't know if folks are familiar with that, but those are essentially agreements that localities, local sheriff departments enter into with the federal immigration authorities, where those like police get deputized to get engaged in federal immigration enforcement. It's a real force multiplier that significantly expands the dragnet that puts people at risk of detention and deportation. We work on campaigns to shut down detention centers. That has been less successful so far, although the Biden administration has shut down two very notorious detention centers, one in Massachusetts and one in Georgia, that had a long record of civil rights abuses. The one in Massachusetts, like right before it was closed, essentially there was a mass protest in that facility. It was in nothing from it. I'm sorry, the name is eluding me. But essentially, like the sheriff came in and tear gassed the detainees who were protesting over safety conditions related to COVID-19. I think shot them with rubber bullets. And then the facility that's being closed in Georgia is the notorious facility where women were undergoing forced gynecological procedures. That you may have seen the reporting on that. So, in addition to the litigation, we do a ton of that advocacy at the federal and state level. We also do litigation in other fora. I do emphasize that. And so one area of work that I'm particularly interested in is building out our state docket, our state court docket. And so we were talking with some folks last night about how we've been looking at, for example, state constitutional challenges to state laws excluding agricultural workers from basic wage and hour protections. What's really great about state court litigation is it's all about state law, and you never get to the federal Supreme Court. It sort of ends at the state Supreme Court. They're the kind of court of last resort. There's just, despite the challenges we're facing in a lot of the fora where we've traditionally worked, there remains no shortage of really amazing, exciting work that really matters to immigrant communities. I think it's easy to forget when things go really south, really wrong in all of these spaces, that there's still really important interventions we can make.
That's a good reminder. So Judy, I wanted to ask you, obviously you talked some about policy decisions that the Biden administration perhaps has fallen short on. If you could identify just a couple key things that the Biden administration could and should do on immigrants' rights that it hasn't done, what would those be?
Just a couple.
I think we've already identified one in Title 42, and that is just sort of, way past due, given that what they've said about, given what the consequences are. It's the first time that people who, under our law, are entitled to apply for asylum are just being, excluded, just go back. So they can end, and that's something that they can end. I mean, that's not, not to say that they won't face some kind of backlash from Texas. I mean, at this point, that I guess is just something just to be aware of. I mean, it's in all of our heads, and I know it's in the Biden administration's head, that whatever they do, Stephen Miller and others are going to be trying to think, what can they do to attack it? But that's one thing. The other thing we were talking about earlier today is to extend temporary protected status to more groups of people. I mean, especially with the collapse of comprehensive immigration reform, that they weren't able to get that. How are you going to protect people who are here and have been here for years? And temporary protected status is one thing. I mean, it doesn't solve the problem, but they have given temporary protected status now to Afghanis and Ukrainians, but all the Central Americans, the Haitians, there are people from African countries. I mean, there are just a lot of countries where temporary protected status would make a big difference in terms of, and it just means you won't also be wasting all this time detaining and deporting people, because otherwise you're spending money, and effort to say, oh, you're illegally, we're gonna, put you in detention and lock you up. And I mean, I guess that have to consider, I'm just thinking out loud now as I do this. I mean, most of the TPSs do have exclusions for crimes. So I don't know if there's a way around that, because a lot of the people who are put into deportation proceedings now, at least within the, in terms of the interior enforcement, they're put in for criminal conviction. So I would say there's also the issue of, there has been, and then I'll stop because I know we really just to go over a few things, but there's the whole interior enforcement and prosecutorial discretion. And to their credit, they did initially want to have a moratorium, and then they were challenged again by I guess, Texas over that, and then now they're being challenged over the enforcement priorities. But I still think that they came out with some new, I mean, the enforcement priorities, because we'll have to see what happens with that litigation. But there may be certain things they can do that can't be challenged, just what they do. You know, they don't have to put people into removal proceedings. They don't have to detain people, but I mean, I guess whether they have to detain people once they put them in removal proceedings is another question, but they don't have to initiate removal proceedings against people. And so I think that that's what I would be saying that they should do. And then there's other things like, you know, more discreet, like certifying certain of the board decisions to the Attorney General. There's certain board decisions like that say that even though you get relief from a conviction, even though a conviction is vacated under state law, it still counts as a conviction that can deport you. It's just crazy. If the state where you are convicted is ready to expunge the conviction because they don't think it's serious. But the immigration statute says that rehabilitative convictions, you know, are not to be, are still convictions for immigration purposes, but there's room to interpret that differently. And there's been a lot of good work in terms of how to frame laws and frame the expungement statutes or the, you know, the post-conviction relief. And still what they're doing right now because of the board decisions is treating those people and deporting them. So that's something that they could do. You know, there's other decisions that I think they could, you know, like in the immigration context, I think they could probably, you know, certify the matter of Joseph decision, which says, you know, who's subject to mandatory detention. We think it should be a different standard right now. Anybody who's tolerably deportable, you know, can be subjected to mandatory detention when it really should be the opposite. That, but anyway, I'm getting too technical. So those are a few
That would be an
things.
important fix. So I want to make sure to leave time for audience
Yeah,
questions.
yeah.
I'm just going to hold the rest of mine. If we have time, I'll get to them. But I wanted to see if, if any of you in the room have questions, and I'll check the chat in another minute.
I'd just like to know, given the makeup of the federal courts and also the fact that Congress basically can't do anything, how do you, yeah, how do you just remain positive, like developing this citizen?
Judy is very positive.
You know, I would say it's hard these days to be positive, but I think it was hard during Trump to remain positive. I mean, and yet I think that I was so grateful to be able to have this job during the Trump administration because I felt like I was able to fight back when I saw, like, you know, whether we won or not, we were able to fight, and I feel like that was really significant. You know, when I compared how I was dealing with things with my friends, you know, who felt much more isolated, impotent, I felt like I had a community. And I think that that's one of the great things about doing immigrants' rights is the community that you're part of, because immigrants' rights advocates are just fabulous. It's just a great group of people. And there's a whole community of people, you know, I'm in New York, but I have a community of people all around the country that I work with and feel, you know, connected to. And so I guess that's the way. And then as Michael was saying, you do see positive, you know, you do see positive things that are going on in the states, you know, so it's not like it's all negatives. And then it was positive that Biden got elected. Okay, so he hasn't been able to, you know, reverse the trajectory, hasn't been as strong as we would like, but it is better than it was under Trump. I mean, under Trump, you know, there really was much more just enforcement, you know, interior enforcement than there is now. So,
Can I add?
yeah.
I mean, for me, I guess like two things. For me, it's helpful, and I think it's hard, particularly given the nature of our work. And we're like federal court litigators, so like we're very focused on precisely the problem you identify. It's just like our day to day. But it's important to remember that the federal courts, the Supreme Court, the federal government, they're not in charge of everything. like it's important to not kind of take a totalizing or monolithic view of how power works in this country. And so even during Trump, you know, when there was a massive crackdown, open season on immigrant communities, you saw many states and many localities standing up for their immigrant residents and like providing very meaningful protection against their detention and deportation. And that's borne out in the stats. This isn't just empty talk. That sanctuary policies and limits on ICE's sort of involvement and intermeshing with local law enforcement provided very significant protection to people in a moment where it was a kind of like top-down assault on communities. And so I think there's all sorts of things and all sorts of places where immigrant communities and their allies and people who love and care about them have real political power and can offer protection, but it's more than protection. Like you see any number of policies happening at the state local level that are trying to make it possible for immigrants to thrive. And so Oregon, California, you can get healthcare now regardless of immigration status. That's like astonishing. Or, you can go to school and get in-state tuition or scholarships, or you can get a driver's license, or you can get, and so all of those things sort of make unlawful status, like the lack of immigration status, less of a kind of disability, and like you're able to kind of be more of a full participant in life, and I think that's important. Like there's still, even with rights retention happening at the federal level and in the federal courts, there are still many spaces where you can make life better and good for immigrants. I mean,
You persuaded?
No.
What?
Maybe a little.
It's easier to feel this way if you live in California. Or New York City. I live in Georgia, so it's like I live in a purple state.
I'm curious in relation to the Title 42 litigation strategy. Did ACLU choose to attack Title 42 as applied to groups who articulated views of public opinion and conventional sympathy levels for those different groups, or what goes into that decision making about what's going to be the first lawsuit filed?
Oh, I just want to repeat it for those on Zoom. So the question is about Title 42 and how the ACLU came to the decision about which lawsuit to file.
Yeah. So I think the strategy was always to work in stages. It wasn't like we were going to do it for kids, but then not challenge it for anybody else. And so part of it was filing suit on behalf of the most obviously sympathetic group of people first. So kids coming to the border by themselves. And also kids, as we know, are differently situated with respect to COVID risk. And also because they're detained in a different system in ORR, which is the Office of Refugee Resettlement, which is more of a child welfare system. Like that also affects the COVID risk. Like you're not seeing the same kinds of congregate spaces. And this, like you have to remember early in the pandemic when we're all very freaked out about this. And so it was both, I think, kind of sympathy to judges and the different risk profile that kids present. But the idea was, once we lock that in, because the arguments are the same, like the legal arguments are the same, that this violates the asylum and refugee laws, that we have a sort of argument that Title 42 in fact does not authorize expulsions, but only bars the introduction of people into the country, and that it applies mainly to transportation policies. So all the arguments would sort of logically apply to Title 42, but there was a very deliberate decision to kind of begin with kids, then families were next, and we're still at families. And the hope is but the ultimate goal has always been, I think, to get the Biden administration to back down. This is not, and I think that's part of how you think about strategy. This is like, we're not trying to litigate everything to the Supreme Court so the Supreme Court has the final say. It's all part of this like more complicated kind of political fight. And the question is, how can litigation assist a broader advocacy effort to stop this terrible thing?
Right, and that's where at least having a Biden administration instead of a Trump administration,
totally.
There's a chance of doing that. Whereas otherwise, it's not going to make a difference.
Given the federal attitude towards international customary law, how do you use that to approach the asylum issue and like violation of treaties and asylum policies around the world?
I don't think it helps very much. I don't know. I mean, you try, but I think that, I mean, I think you can appeal to some of the judges. I mean, if you're talking about in the courts, or you're talking in the courts, I mean, some judges will respond to it. I think it's more to use it to interpret what our own statute requires. I mean, our own statute requires that we be in compliance with the Refugee Act and the Convention Against Torture, with some exceptions. And so you point to how what we're doing is inconsistent with those norms, and those norms then have to be used to interpret what our obligations of the statute. But ultimately, I think that we have to get them to see that, you use it to show how they're violating what our statutory obligation is. Because our statutory obligation was, the Refugee Act was enacted to bring us into compliance with the Refugee Convention. So then you say, well, under the refugee, and then actually Eunice is probably the best place to,
Yeah.
why don't you answer this question?
I mean, in all of your case, in most of your cases that involve, claims about access to asylum or that you do get, UNHCR often weighs in as amicus.
Mhm.
And I mean, as Judy said, it depends on which court, to the extent to which they're receptive to that. But in all the major cases that you're talking about, you have, UNHCR has emphasized the violations of international law. And then, of course, the core argument is that these have been, that international law, I'm not sure, but they've been enacted into domestic law through the Refugee Act.
Do you want to add?
Yeah, the customary international law may be harder, but as Judy's pointing out, it's the statutes, like with the torture convention, the US statute says it is a policy of the United States to implement the Convention Against Torture, so you're directly using international law. But you're asking specifically about customary international law?
Yeah, just because that's what I know about. But I know like the treaties as well, and I just realized that we're in violation of asylum protection.
I mean, the only customary international law that comes to mind has to do with withholding, which is in our statute, so, I don't know what it has except for what, Judy's saying.
I'll just defer to you guys then.
Your questions?
I think you had a question.
Yeah, my question is somewhat related to Devin's question. That I think all of us in this room can probably say that this topic feels very personal. And some of us have very personal connection to it. And so my question is, as your development as attorneys and throughout your careers, when you're confronted with people in your family, in your community, the kind of messaging that we have seen amplified during the Trump administration, and when you are asked why it's important that you do what you do, and why we should let them do X, Y, or Z, or have X, Y, or Z, how have you learned, or what do you do to kind of separate the very personal kind of top of my head wants to blow off reaction to articulating an argument that might reach somebody from that perspective, to try to make that connection, to explain why we all know this is important, but why it's important, why it should be important to somebody who might not see that.
It's a really good question. I guess I would say, how do you do it? I mean, because I feel like it's obviously something that, I don't really have an answer. I think it would depend on who I'm talking to and what the specific issue is, and I might be effective and I might not be effective. So I feel like it sounds like something that you've had to struggle with.
I'm a work in progress.
And how do you, and what do you do? What sort of, or the advice that you would give to other people?
I waver between going into the stats about how immigrants help the economy to going into the very personal stories that I have worked with, and lived for years, which are neither of which I think is particularly effective. always. And so that's why I'm curious for attorneys who have worked in this so personally, affecting policy for so many years.
Yeah, and I think
If you
that,
had-
we're litigators, and so, this is what you're talking about, is really, how do you change minds, communication, public education, and, I've got some ideas, but certainly not, not someone who has, I don't know, I mean, to me, it feels like, I do think that there has been, and I could be wrong, I don't know where I get this from, I do think that there has been maybe a shift towards, there was more of a shift towards people wanting comprehensive immigration reform, so that there's some, along with, you can have like a disconnect where people support Trump, but then they also support DACA, so to me, I get, what gave me hope was like seeing cases where, during the Trump administration, where, people came to the defense of people in their communities who were being deported. And they said, they might have been Trump supporters, but they said, this person's part of our community. And so there's something about the connection, the personal knowledge. I mean, I don't know how you tell someone that, it's what they live.
Yeah.
And maybe one thing would be that I would say to people is, I don't think people understand how the law works. People say, what is it that they don't understand about legal? Just come legally. And so I want them to say, what is it that you don't understand that people can't come here legally? That there's no way for this person to come here legally. This person is a lawful permanent resident. They can't bring their kids for 20 years, or just, something that allows them to know, you're in another country and you want to come here. There's no way. There's no way if you're from a third world country. If you're from Europe, yes, you can get a visa and come here. But if you're from Mexico or any, I guess third world is maybe not the right word to use anymore. But if you're from, other countries, you can't get a visa to come here. How do people come?
I mean, I think that this is where the media comes in, because what do the media do? It's always starting with the personal story. It's always explaining, and that's what people relate to. They're like, well, I think, illegals, whatever, but geez, this person really went through a hardship, didn't they? And like, it's just people relate to personal stories. So I think those stories are really important. And of course, they're so fraught, because they're always looking for the good immigrants. And then you have to find the story that makes the not good immigrant relatable, and, what are you gonna do?
But I'd like to open up to everyone here. I mean, what do you find works for you if you're talking to people who disagree with you? Do you have any things that help?
I have a life policy of not doing that whenever possible. I'm like trying to conserve my energy to support people in crisis. And I feel like it's rarely effective, especially if you're coming from such a different place, like in arguments with my family or my partner's family who are Texas evangelical conservatives. I would say, if you would like to read this list of sources and you would like to send me some, then we can have a conversation after, but it's not worth our time otherwise. I think it is hugely upsetting and disturbing, and the work is disturbing enough.
So I feel like I've kind of been motivated, and a lot of these stories kind of touched very like close to home for me, with like stories of deportation, my own family and stuff. So I think in these moments, and even having this opportunity in law school, I feel like I'm gaining more courage to kind of share my stories in areas where people might not know that even someone sitting in the classroom with them might have had that story that really touched close to home for them. So I think just gaining that courage for me and sharing that, I think has I hope helped change some people's minds, and just I think that's an important thing for me to be able to share with people too. So I think that's how I've kind of seen my role growing in this whole context.
Thank you.
I think it's a little bit of a slippery slope that we start that approach of trying to share feel good stories so they understand the other side, whatever you want to characterize that. starts to feel less discomfort with notions that it sort of plays into that the registers of need of deserving immigrants versus undeserving immigrants. We talked about yesterday reading the abolitionist literature, right? That we should deport real criminals, like really bad criminals, but we shouldn't deport petty criminals, maybe, or maybe just only criminals, but not, So I'm rolling out stories of, model refugees who come to America and, Madeleine Albright or Einstein or whatever, right? I'm not really comfortable with that. I mean, that definitely works for some people, but I don't think that should be.
Yeah, no, I would want to tell the stories of the people who are considered the bad immigrants. But you're right, you're not going to take the story of, a mass murderer who's, but most of the people who are deported, for crimes are not, mass murderers.
Can I ask a really question? So because you tell us that you litigate, well, so Biden administration builds rules and gets litigated by the Attorney General in Texas or Missouri or whatever, you obviously keep your eyes on rulemaking. So what might make you apprehensive under Trump, for example, when you litigate it? What about what's going on now? What rules in the offing are actually making you happy? Or what might be in the offing? Or what is actually making you apprehensive? Is that a reasonable question?
Yeah, I mean, and I think part of it depends what the rule looks like when it comes out. The next one that's coming, and we'll just do one because I think we're under time constraints. There's a big asylum rule coming.
That's right.
From the Biden administration that is in part meant to kind of be a core component of how it's going to manage asylum at the border. And, I think there's a lot of, I think people are of divided minds about it, and people like parts of it and don't like other parts of it. I mean, like one of the major innovations is sort of the rule proposes to give more authority to kind of asylum officers, frontline asylum officers who are traditionally doing the initial screen of people coming across the border, to just grant them asylum outright when they're clearly eligible for protection. And I think for the most part, people think that's a very good thing. And the hope is that that will relieve some of the pressure at the border, where people don't need to be locked up as long and go through these crazy court proceedings when it's just very clear on day one that they should just be granted asylum. So I think that's good, but there are concerns about other parts of the rule, like for people who are denied and what kind of access to court review they're going to get. And so I think, we'll see. But that's sort of the first thing.
Well, we are at time, so I want to just close the formal part of our session here and thank our speakers so much for coming in person.